Although she's knowledgeable enough that someday she could hold that position. Nebraska Supreme Court Commission on Children. Correct. And the court's a member of the OB 961 Advisory Committee. Good, we're on a roll. A team coordinator for the Lancaster County Through the Eyes of the Child Initiative Task Force. Only until next Tuesday. She plays the trumpet.
I didn't bring it with me.
Yeah, music major.
And director, so if I start getting up and marching around.
And I
See that kid?
And I took up with Southern County, so I asked my colleagues who do Lancaster, what can you tell me about her? And the comment is, she rocks, which means she knows what she's doing, very intelligent, she gets the job done, which is what she's going to do now. Alicia.
All that I really am is a poor struggling prosecutor trying to figure this stuff out. And Carol Stitt is very persuasive and has made me do some presentations on it. And every time I've done it, I've changed something because I keep learning more and reading the case law a little closer and trying to figure out what all this aggravated circumstances, reasonable effort stuff is all about and cases. And you'll hear at the very end of this that at the last week, I actually argued a case in front of the Supreme Court where I hope we get a little more clarity on some of these issues. But I'm at least going to tell you a little bit about what I've got going now. You should all have the PowerPoint, hopefully. I'm not on your little flash drive because I finished my presentation Tuesday at 8:30 p.m. before I drove down here because I'm a procrastinator. But at some point they'll put it up on the website, you'll have it. But also I have some statutes. Where'd the statutes go?
Right here.
Okay. We're passing out the statutes and you're going to have to share because I don't think I have quite enough of them for this number of people. But just so we can refer to those for the interplay between reasonable efforts and termination. So hopefully you'll have the tools you need to, make this happen. I'm sorry, but I used to be a professor, and so I'm going to be a little too professorial, I think, during this, because I can't quite figure it all out. You all know, and I don't know how to, I hate this thing. Okay, this is forward. There we go. You all know that we have a duty to use reasonable efforts, right, to reunify the family. And you can read that first slide, and you've all probably all read it before. But reasonable efforts shall be made. Those are the phrases, right? To preserve and reunify. Now, there are exceptions, and I'm going to speak mostly about exceptions today, although I'm going to go through the case law that talks about when reasonable efforts are required, how we can determine those. So, first of all, you have to use reasonable efforts to reunify unless a court of competent jurisdiction has determined one of the following. All right, and we'll go through some of that. Who's a court of competent jurisdiction here in a minute. If a court has determined that the parental rights of the parent to a sibling has been terminated involuntarily, that's one reason to not have to use reasonable efforts. Okay? So we all have those cases where we have a termination of parental rights and mom has another baby. Okay? That speaks to that. Or the parent has committed, and I shortened this up, and you've got the statute in front of you, and you should keep it in front of you at all times as you're looking at new cases to say, is this one that fits? The parent has committed a specific type of felony against the child or another child of the parent. And obviously, if you murder one child, you couldn't have murdered the child you're talking about in your petition. Or the juvenile's mother. There's a recent change in the statute where that if you sexually assaulted the child's mother, that's a reason for no reasonable efforts to be required. Okay? A pretty specific amendment to the statute, probably won't apply in a lot of situations, and it's very specific. It's the statute in Nebraska. Or the parent is subjected to juvenile, and that's how the law used to read, just the juvenile to aggravated circumstances. Because of some of these talks that Carol has, ordered me to do, and I've done for her. She also then got me involved in a situation where we could actually change the statute. And so I had this fabulous experience of getting to quickly pull together what I thought changes in the statute were, run it down to a senator, have the senator go, yeah, I think that sounds good. The next day, run to the Judiciary Committee and say, I think we ought to amend it this way. And it came out of the Judiciary Committee that way and got adopted. It was like, and Carol, we get done and Carol goes, that is not how it works. It just doesn't work that way, Alicia. We have to bargain and, anyway, it worked that way this time, so that was good. The parent has the changes, the parent has subjected the juvenile or another minor child to aggravated circumstances. So no longer do we have to have that one child be, severely injured or whatever, but it also is a different child. And it doesn't even say sibling. You notice, it says or another minor child. So if you're the boyfriend and you hurt your girlfriend's kid and you've got another child over here, that could be considered an aggravated circumstance. Okay, so that was pretty fun to have that happen and to make that law change. But anyway, let's talk about first of all the times that when reasonable efforts are required. Okay, when is it that we look at when reasonable efforts are required? And Dwayne G. is a case that everybody ought to read. I didn't provide you with a copy of it. You can look it up yourself. I did give you the site to the statute. And it tells courts when to review reasonable efforts, when reasonable efforts are required. Okay? And that's like the first half. This is when reasonable efforts are required. The second half of my talk is going to be when they're not required and how we determine that. This case started out as a neglect case involving the mother, and then a 3A and a TPR was filed on what I call the dangling dad. And I don't know about any of you guys, but that whole notion of us, and I am a prime example of how to screw something up. You have focused on the mom for so long, and then all of a sudden you go, oh yeah, there's a dad. Yeah, every kid's got a dad. And we haven't done really anything to try to, figure out who the dad is, or to go after the dad, or find out what his circumstances is, or enfold him in, and bring him in, and try to get him involved. And there was a whole talk on that. Okay, and I went to that because I've made a lot of mistakes in this regard. Anyway, the TPR and the 3A was filed against the dad. And the dad asked for a separate hearing about the fact that no reasonable efforts had been given to him. And Dwayne G. said that no party can bring a motion requesting a separate hearing about reasonable efforts. Now, in Lancaster County, we've been doing that, so whether or not we can or not, we have been. But this case will tell us when it is that we for sure can. It tells us very specifically, if reasonable efforts are required, it must be reviewed by a court in 4 circumstances, and they're pretty straightforward. When is that, and RE now stands for reasonable efforts, okay everybody? When is a court going to review reasonable efforts? This case tells you whenever you're removing the child from a home after adjudication. So if you have an adjudication on a 43-247-3 or a 4, and they should say 9-2, but they left that out. Then you always have to look at reasonable effort. So if you've done an adjudication and you've removed a child, you've got to make sure that court is reviewing reasonable efforts. Because of this statute, when a court continues an out-of-home placement pending the adjudication of a case. So to me, this is your temporary custody hearing, right? You've removed the child from the home on an ex parte basis. You go to your temporary custody hearing. This is when the court has to review, obviously, reasonable efforts and whether reasonable efforts are being made to try to reunite the family. That is a forum for folks saying no reasonable efforts have been made. They're not giving us enough. They're not bringing, defense attorneys. This is your first shot right here. The next time is when the court, anytime the court reviews the child's status. So every review hearing, so every hearing after that, the court has to be reviewing reasonable efforts. And so if you as a defense attorney or you as a prosecutor are saying these people are not giving these folks reasonable efforts, you should be, and you can be, filing a motion to say, I want a specific review about reasonable efforts about this, on this issue. Or you can just sandbag them and not tell them that's what they're gonna do, and then walk into the hearing and, start making a lot of noise, and maybe there will be no reasonable efforts finding. Most prosecutors do not want there to be a no reasonable efforts finding. Do you know why? Because it's one of our bases for termination. That reasonable efforts under the direction of the court have failed to correct the conditions. If we get a no reasonable efforts finding, we have now just gotten rid of a whole one of the ways that we can terminate. So no prosecutor wants there to be a no reasonable efforts finding. Now sometimes we're just mad at the department, we think it'd be fun to stick it to them. But it doesn't help us any if we do that. So it'd be better to try to work with the department. I'm so good at that. Everybody who knows me knows I really work well with the department. I'm usually yelling at, poor Holly's back there laughing. My caseworker knows that I'm kind of grousy to live with. Anyway, and then obviously there's your last section. If were reasonable efforts provided so that the parent did not rehabilitate themselves, and that's a basis for termination. Those are the 4 times that you look at reasonable efforts when they are required. Yes, ma'am.
So do you in this case to preclude a situation where, say, the parent's attorney brings a motion, like it sounds like his dad in this case, for no reasonable efforts, if there's a separate hearing, how? Or should that be couched as, for example, a review hearing?
It clearly says you're not entitled to a separate hearing on the issue. So it would have to be brought up during a regular review hearing or a regular dispositional hearing. So, however you could get the court to do an early review. You can always ask for an early review and then bring up as part of the early review the fact that reasonable efforts haven't been done. And you could sandbag, or instead you could say, I want an early review in this case, and then I want to talk about reasonable efforts. But Dwayne G. does not set forth, although there's some attempts by the Court of Appeals, I think, to say that, and I even argued it last week myself in front of the Supreme Court, and we'll talk about that in a minute, it doesn't really tell us when or how we get to the situation where we want there to be no reasonable efforts required. We think we have an exception to the duty to use reasonable efforts. It doesn't really speak to that at all. And so now we're going to kick over to that part. You've got that bad case. We've all seen those bad cases, and we're kind of going, God, we really have to try? You got to be kidding me. Do we have to try to reunify? Okay, so how do we determine, and when should we determine that reasonable efforts are not required? I'm going to go through Janet J. both the first time it went up on appeal and the second time it went up on appeal. And so the first case is the first time it went up on appeal, an unpublished opinion. Okay, you can read it, but it's not precedential, it's just an unpublished opinion. This child was born to unmarried parents. The mother had previously been convicted of child abuse on 2 of her other children. And the father in this particular case had intended to stay with her. So he wanted to raise the child, the mother wanted to raise the child. Now, I gotta get my thing here, sorry. You didn't know that you were gonna be sitting right on top of me. There was some evidence presented about what the mother had done to the 2 previous children, and just for gory details, I'll fill that in here. The history and Florence's testimony, that's the mother, are the only evidence in the record which clearly established what Florence did to her earlier born children. It shows that Florence's child, Sandy, born in 1988, was taken to the hospital at a later date with a spiral fracture of her right femur, and she died on September 17th. It shows that Matthew was born on February 19th, and this is 92, so 88, 92, was admitted to the hospital on March 6th with a spiral fracture of his right femur. The pathologist opined that Matthew's injury resulted from excessive force being applied to the leg with a twisting motion. We've heard this all before. And the caretaker would have had to have inflicted the injury knowingly. The testimony that Florence gave at the adjudication hearing was that she admitted that she placed the child, Sandra, who was alive at birth, in a box in the closet of her residence a couple of minutes after she was born. She did so because her mother didn't know she was pregnant, so we're thinking young mother here. And because Florence was afraid of her mother then took Florence and Sandra to the hospital. Florence admitted that Sandy had a spiral fracture of her leg at the time of her death. She also testified she hurt Matthew by pulling down on his leg while trying to change his diaper. Later in her testimony, she admitted that she was responsible for the injuries to Sandra and to Matthew. Okay, and so then we have baby born in 2002. So 88, what did I say? 92, 2002. She's 10 years older, right? Okay. This is a prosecutor's nightmare as far as I'm concerned. It's like, oh my gosh, what do we do on this one? Okay. The prosecutor filed the situation dangerous the minute the baby was born, okay? Saying that this child was in a dangerous situation. Not saying this child was abused by the parent, because obviously it wasn't. It was just came out. And it obviously was not drug addicted or anything else. Come on, go. Now I'm going to do the old aside here for a minute. Why didn't the county attorney file a termination of parental rights? You can get out your statute under 43-292, subparagraph 2, or subparagraph 10. This is the audience participation part. Take a look at, and if you're a county attorney and you're looking and you go, okay, so somebody, what does 43-292 sub 2 say? Parent has, I'll read for you. I have the microphone. The parents have substantially and continuously or repeatedly neglected and refused to give the juvenile or a sibling of the juvenile, ooh, there's nice language, necessary parental care and protection. How many people think that Matthew and the other baby, Sandy, did not get necessary parental care and protection and were, fit that statute? You get rated fan. Okay, yeah, everybody does, I hope, unless you were like asleep, and that's fine, because, you had a late night last night. Why didn't the prosecutor file a motion to terminate parental rights? Why? Because of dad? Why not? Can't we terminate on one parent and not the other? But why?
Because they're together.
What's the department's policy about termination of one parent when you have an active second parent? They don't want to do it. Why? Why? That's a good question, is the answer up here. Good question. Why don't we want to terminate on one parent and not another parent? It's a source of support, literally, money, child support, right? What else?
You're not freeing the child for adoption.
You're not freeing the child for an adoption, right? But what do you say? What about protection?
Two are going to be together, so then if you terminate, you get out for life, you don't have to substitute your dad, and they're still together, so essentially she still has parental rights, even though they're not legal.
You can keep your eye on the family if you continue on, perhaps, right? Okay. All sorts of reasons, and this is really hard to explain to most folks, It's like, oh my gosh, she did this, and she gets to have another baby, and she gets to, we get to try it. Okay. So anyway, the county attorney did not do that, and it's because of the data, I'm convinced. Of course, I haven't talked to the county attorney, so I don't really know. I'm just guessing. Okay, so the child does get adjudicated. It's in a situation dangerous because it's got a mother who's, killed one or two or however. I can't quite figure out from whether both kids died or not. Appeal was taken, it was affirmed, and it was remanded for disposition. Okay, so all the county attorney had done was filed a 3A case. Period. Okay. You all know what 3A case is, right? That's the okay. Yeah. I don't know who I'm talking to. Actually, this will be a good time. How many prosecutors are in the room? How many county attorneys? Okay, lots. Okay, how many HHS folks? Lots. How many judges? Fewer. How many, what else? Foster care review board? Quite a few. JLs? Parents, attorneys, both? Okay. All right. Anybody else who wants to pipe in and say that they are something different? Okay. Right there. All right, so now we're back up again. After it gets sent back to so we've just had a 3A. Everybody's got that? That's all the prosecutor filed. we go back, and now we're at disposition. So we can pretend the first appeal didn't even occur, right? Except for time's passing. Okay, so we are now at disposition on the family. And here's what the court did. It approved a case plan which did not provide for reasonable efforts to reunify with the mother. Okay? And what happens? An appeal is taken. The mother and the father actually join in the appeal, but the father actually, they were going to try to reunify with father, but they had no reunification efforts with the mother. All right? They're still together though. So the dad joins in on the appeal, but only on the mother's issues. I don't quite get that, but that's okay. So the issue on appeal was there a duty to provide reasonable efforts toward reunification by mom, or was it instead excused under one of the 43283.01 subparagraph 4 exceptions? Okay? Everybody's got it, right? Okay? Nobody filed a motion for reasonable efforts or for no reasonable efforts. Nobody filed a petition that said that we shouldn't have to use reasonable efforts. We are simply at disposition where this is happening. Okay? So what does the Court of Appeals do? They say, yep, there is no duty to provide reasonable efforts, upheld the trial court's dispositional hearing, and determined that the evidence of the dispositional hearing showed the mother had committed a felony assault resulting in serious bodily injury to another minor child of hers. Now, how did that happen? You got any ideas? People call witnesses?
She was convicted and they showed.
No, she wasn't.
She was convicted of child abuse, so it didn't fit serious bodily injury. If you've read the case, you know, not that you have, but she'd only been convicted of child abuse. So the court actually had to take the evidence in front of it at the dispositional hearing. Now, what kind of evidence was that? The case plan and the court report, that history section. Nobody objected to the history section. Parents' attorneys, you ever saw something like this, man, you would be objecting to that case plan coming into evidence with all that history. But the Court of Appeals said, we can consider that history, so could the court. Nobody objected to it, it's in. There was a letter apparently from the pathologists or doctors of the first kids. There was, they put in the evidence of the mother at the adjudication hearing. So the county attorney must have gotten the transcript of the adjudication hearing typed up, offered again in the dispositional hearing. Yes?
It's not correct.
It's not correct? Oh, because you're it. What did you do?
It was, they took the evidence that was introduced at the adjudication hearing and what was introduced at the first appeal to make their determination in the second appeal, because there was none of that evidence was introduced at the dispositional hearing.
What? Nice de novo review.
Because I remember them saying that they took judicial notice.
Oh, they don't say
prior
that in
appeal.
there. Interesting. Very
And
interesting.
the evidence that was introduced at the prior appeal, because the argument was made that she was never convicted of any of those specified arguments, and they said, well,
Her
based
testimony at
on
the
the
adjudication.
testimony at the adjudication, we find that this in fact did occur.
Okay. So if I'm a prosecutor, I don't want to do that. I'm going to have my evidence from the adjudication hearing typed up and offered as an exhibit at the, unless somebody's going to agree that the court can take judicial. It was. Okay.
Why
And
couldn't the judge just, if they heard adjudication, they could use that for the disposition?
you're more in trouble as a prosecutor if you do that. I mean, the cleanest thing to do is to have it typed up. I mean, that's what they tell us about judicial notice.
And it was because of the prior appeal. that
Correct.
the transcript of it.
Okay. So that's good. And so you did offer that in your dispositional hearing? You did. You
I
did.
believe they did.
Okay, so there was evidence.
So there was evidence of her. Okay.
But they were just different.
So, you know, that obviously your adjudication, if you're a prosecutor, think, okay, so for having this, we've got this evidence. There was also apparently letters, at least, from the pathologists or doctors or something that came in somewhere into evidence showing that the prior abuse would have had to have been intentional. Is that fair to say?
I think so, I can't.
Yeah. You know, but the court, even though there was no actual trial on or conviction of child abuse, the court had enough evidence to make a determination that the mother had intentionally or knowingly committed a felony assault resulting in bodily injury or serious bodily injury is what we'd have to have, to another minor child of hers. That happened at the dispositional phase. So all I'm telling you is that even if you can't get it there, you could get it at the dispositional phase. You just got to make sure you've got enough evidence. Now the one thing that Janet J. did is that it said that it only had to be proved by a preponderance of the evidence. Okay, that's not the law anymore. That gets reversed or disapproved in a subsequent case, which I'm going to talk about in a minute. Okay, but Janet J. is still good law, saying it can happen at disposition. Doesn't have to have a separate hearing. Doesn't have to have any separate pleading. Doesn't have to do anything. And quite frankly, if the department comes in and says we don't have to use reasonable efforts, it's up to the judge to decide whether or not we have, by clear and convincing evidence, proved that there's no duty. Here's the caveat. Come on. Obviously, okay, dispositional hearing is one place we can do it. They clearly say that the juvenile court is a place of competent jurisdiction, or a court of competent jurisdiction to determine that an exception exists. But it also could be if she had been convicted of of a felony assault resulting in serious bodily injury, all you'd have to do is take a copy of that and put it into evidence, and then have some evidence that the person who's in that complaint was a kid of hers. So there's your criminal conviction that will work. It's got to be a final order. This case is really funny because the prosecutor did a trial, and the parent had been convicted of like murder or something, and we were of another kid, and so they're waiting, but it was not final, and the prosecutor had offered the conviction into evidence in the abuse case, but it was not yet a final order because it was on appeal. So the Court of Appeals waited around until it got affirmed on appeal, and then took judicial notice that it had been affirmed on appeal, and then said, okay, now that it's affirmed, it's okay, and we'll say that the prosecutor's evidence was sufficient in the court below. Wow, that's exciting. Anyway, and obviously, if you've got a prior termination, get a certified copy of the prior termination order, tie it in, that that's the mother who was terminated, and that should be sufficient evidence. Okay, this is the troubling part. If the prosecutor, whoever approves it up, doesn't have to be a prosecutor, it can be the department, it can be the guardian ad litem, it can be anybody who proves up that one of the exceptions exists, are still no reasonable efforts required. What does your statute say? Okay, we've proved up number 4301. 283.01 for C. Okay? Dispositional hearing, evidence is offered that there's a prior termination of parental rights of the mother to another child. Are no reasonable efforts required? You guys know this is a trick. This is a query up there, right? Come on, just give me the obvious answer.
Yeah.
Are reasonable efforts required if we've got an exception to the requirement to use reasonable efforts?
Yeah.
No! Except for Janet J. Dang it, right? Okay, so here's what Janet J. tells us. And I don't know where they get this from. The words of that and the legislative history, okay, that's where it comes from, clearly demonstrate the juvenile courts must still consider and determine whether the best interests of the child require reasonable efforts, even though we found one of those things to be true. So you've got this great reasonable efforts law that says you don't have to use reasonable efforts, except for now they say, yeah, you do, if it's in the best interest of the child to still do it. Boy, we just went through a lot of work for nothing. Okay, I can't find another case that says this. It's a Court of Appeals case.
It's what they felt on that particular day.
Have you done a lot of arguing in front of them too? Sometimes you just want to go, okay. Anyway, I'm not going to talk about that Chance R case or Chance whatever it was case that hopefully the I can't find another case that says this, but so this is good law right now. You still have to show it's still in the best interest of the child not to rehabilitate. Okay, so in Janet J, what other evidence did you have, since it's not just some prosecutor? Did you have, well, there was an evaluation of the mother done, and that talked about really where she was psychologically between 1988, 1992, and then 2002. So because you had a dispositional order, by that time you got an evaluation of the mother, and they were able to show that nothing really had changed. Yeah.
Who wrote that opinion?
The judges.
Was it written by anybody or who was?
Do you remember?
No, I don't.
Okay, let's look. This was the Court of Appeals one that, yeah, okay, this is it. Hannah. So,
how do you take care of that, practically speaking? Then you, in that same hearing, ask for finding about the best interest?
yes, you would also want to have a best interest finding by the judge, because otherwise it's going to get reversed on appeal in a de novo review saying that, you know, we still have to look at best interest. So as a prosecutor, you got to first prove it, then you got to show that nothing's changed since then, so you can show best interest, and then you're going to ask the judge for a finding that the best interest of the child requires no reason, or, you know, mandates that there be no reasonable efforts at all to reunify. All those things at a dispositional hearing. That's what I'd be doing now that I've finally, you know, done this talk 1,500 times. Okay. When else can we do it? Then you get to the case of Jaquez. Now this one is a Supreme Court case. And in Jaquez, oops, wrong way. It was a severe head injury case involving just one child, okay? So this child, of course, had a fracture of the right leg. Right legs apparently are very, very susceptible to fracturing, because these poor kids all had right leg fractures. Does that mean their parents are left-handed? I don't know what that means. Anyway, but also it was a severe head injury case. The child was deaf, I believe blind. I'd have to look at it again. It was shaken baby. It was more likely dad than mom, but there wasn't any clear evidence that it was dad versus mom. But very clearly, mother delayed medical treatment by her own testimony and by other, you know, other individuals' testimonies for 2 days. Okay. So this is, I think it's an Omaha case. Is it? Yeah. The 3A petition, motion for termination of parental rights, and a motion to excuse reasonable effort. So the prosecutors just went boom right out of the chute at the adjudication and said, you know, we don't want you to have anything. Brought against the mother and the father. State prevailed against what? That lady, that was scary. Oh, wow. Oh, I love you. Thank you, Darren. I can keep talking. The father didn't appeal. The adjudication was only neglect against the mother. The court below said you didn't prove up the termination of parental rights and you didn't prove up the excuse for reasonable efforts. Okay? Mom's delay in medical treatment didn't matter to the court below. The state appealed. Okay? There we go. That's it. That's where we are. Oh, you can even tell where I'm at. He is very good. So the state appeals this one because all they got was the 3A on mom. And they're going, you gotta be kidding, right? Okay, so they appealed it. They are delighted with de novo review. Most of the time the prosecutors hate de novo review because we want it the court below, we get up to the Court of Appeals, and they read the cold record and they go, not enough, and they send it back down and we've lost. Okay. The Supreme Court reverses, which is yay, good for the prosecutors. And we want to say good for the baby who was blind and deaf as a result of the shaking plus the delay in medical treatment. But the one thing the court does is it addresses the motion to excuse reasonable efforts. Now, think about it. The prosecutor filed a termination and a motion and a 3A. Well, We'll get to that in a minute. Just pause there. They upheld the termination under 43-292-9. What is that? What's 9, you guys? Aggravated circumstances. Okay, they said it's aggravated circumstances under the TPR. Jaquez, because it also addressed the reasonable efforts excusal, went back and reversed Janet J. and said, prosecutor, you have to prove that there's an excuse to reasonable efforts by clear and convincing evidence, just like you do in the termination, because it's basically tantamount to a determination of termination, really. So dispensing with reasonable efforts at reunification amounts to a substantial step toward a termination of parental rights, and you've got to prove it by clear and convincing evidence. So that's what that's the only part of Jaquez, or of Janet J, that Jaquez says, no, it wasn't right. So Janet J is still good evidence or good case law on you can do this at dispositional hearing, and this one says you can do it at adjudication. It tells us what aggravated circumstances are, and it's one of those things that we would say a circular definition. Aggravated means aggravated. It's so severe or repetitive that to try to reunify would compromise the safety of the child. In other words, it's one of those, you've got to be kidding me. We're not going to put this kid anywhere near that mother again or father. Another definition that they cite: the circumstances created by the conduct creates an unacceptably high risk to the health, safety, and welfare of the child. Now remember, this is not one where we had baby number 1, baby number 2, and now we're on baby number 3. This is we just shook this kid and then we didn't get medical help for it. Okay. Should the Supreme Court have addressed the state's motion to excuse reasonable efforts? I'm just hearing some no's and other people going, I don't know where she's going on this. Okay. Wasn't the motion to excuse reasonable efforts moot once the court terminated parental rights and once the court upheld the termination of parental rights? Shouldn't the Supreme Court have said, we're not getting to that issue? Now maybe they got to the issue because they wanted to reverse Janet J.'s burden of proof by only preponderance of the evidence. Okay, so maybe that's why they reached it. I don't know. But let me restate. If a TPR has been proven at the beginning of the case, why are we talking about reasonable efforts to reunify? It doesn't make any sense. Or an excuse for reasonable efforts to, it doesn't make any sense at all. Do we have to plead and prove that one of those exceptions exists and one of my termination grounds exists? Now the only way this makes sense, in this case, it doesn't make any sense to talk about this, because it was an aggravated circumstance under the TPR, and it was an aggravated circumstance under 43-283.01. But let's take it out of that circumstance, and we all know what that is. Here's my example. A mom suffers a persistent, untreatable mental illness such that she cannot and will not in the reasonably near future be able to parent. Okay, you're a prosecutor. Which section do you file a termination under? It's 5. The parent is unable to discharge parental responsibilities because of a mental illness, and there are reasonable grounds to believe the condition will continue for a prolonged, indeterminate period, right? So this is your, mom who gives birth in the regional center. Not that I've had one of those in the last year, but I have. Okay. She's got a baby. We don't know who the dad is because she doesn't know who the dad is, and maybe she just doesn't know who the dad is, okay? Could we pursue a TPR immediately? Yes. Why? Because it fits 5, right? And she's in the regional center, and how are we ever going to, wouldn't it be in the best interest of this child not to have to live at the regional center with her? Because she's never getting out. I mean, she's staying there forever. Those are my facts. And I don't think my mom's ever gotten out. I think she's been there for 2 years now. Oh, not my mom. All right. Actually, my dad needs to be there because of my mom. Or does the court have a duty to provide reasonable efforts anyway? look at 43-283-01 and tell me if any of those exceptions to try to reunify fit this situation. Did the mother subject the juvenile to aggravated circumstances? Well, the subject means you did something, right? Did the parent commit? No, she hasn't murdered anybody or done any of those things, and she hasn't had sex with anybody forcibly, and and has her parental rights been terminated involuntarily before? No. Okay. Do we have to try to use reasonable efforts because this reasonable effort statute trumps the termination statute?
But there's a reason why maybe you might want to do that.
Why?
Well, perhaps there's going to be guardianship, in which case, the mother can function, create a position where she can function, she can still have limited contact with the child.
Okay, there's one argument. Did you guys hear what she said? Say it louder, turn around. Oh, wait a minute. Stand up, march, left, right. I've got the microphone. Should I restate it? Because maybe you could find out you should do reasonable efforts toward guardianship. That maybe the mother could be able to function in some sort of manner, right? Okay, there's your one argument. You were not there last week in front of the Supreme Court. Good. Because I was arguing this. I was trying to argue this, although there's never enough time. Oh my gosh, 10 minutes? You gotta be kidding me. All right, so all I'm telling you is we don't know yet if you file a termination at the beginning and you prove it, whether this reasonable effort statute comes into play at all. We have to prove it or you don't have to prove it. That's what I'm telling you. You guys get it? We don't know the answer yet. If I am a prosecutor and this case that I'm going to talk about next doesn't get to it, I'm going to file termination and a request to not use reasonable efforts at the beginning of a case if I believe I need to, because I know this case tells me I can. Okay. This case I've been laughed at a lot in the county attorney's office because it took me 22 days of trial to prove this case. But the evidence came from 16 years of this mother's life, so I say that takes a little time. Hope L. I argued it last Thursday in front of the Supreme Court. It was a abuse case, medical abuse of 3 siblings. It's undoubtedly a Munchausen by proxy case, but I kind of limited my issues on appeal and just let that kind of dangle out there. But that's really what was going on, and I just didn't want to argue about whether Munchausen by proxy was real or not, so I just left it out. So a medical abuse of 3 siblings. The 4th was born while we were waiting trial. It's a very interesting story about where mother went to have her 4th baby. But we got the child into custody, and it was born before trial. We consolidated, everything all came together, filed a 3A, a TPR, and a motion to excuse reasonable efforts. I won, yay. And last week I argued it. Of course there's questions like, are they going to uphold the TPR? I think the answer, you can kind of tell when they're like ripping you a new one that you lost. This time they didn't rip me a new one, so that's good because I lost a couple times up there. I knew it before I left the courtroom. This one, I think I'm going to win that part. Just from the questions that were being asked. But I think it's more interesting is whether they'll address the reasonable efforts motion instead of because I did argue in my brief, it's moot. It should be moot at this point in time. I don't know if they're going to address it or if they're not going to address it. They could dock it or they could address it. Now it was kind of nice though because Chief Justice Hebekin was asked the defense attorney. So do you guys know the case of Dwayne G. and the defense attorney had to go, not by name. And then asked the next attorney, because there's a mom's attorney and a dad's attorney, of course, and asked the mom's attorney, do you know about the case of Dwayne G? Not by name. That felt really good. It's like, I know that. So hopefully they're thinking along the same lines that they've sort of set forth when we address this, and if we've got a TPR, we don't have to address it. So I'm hoping that's how it's going to go. You know, so they could duck it, or instead they could just really go for it. So look for Hope L. Will be coming out whenever they, you know, check the Friday thing and see if you get an answer on this. It'll be I think it'll be very helpful to us to actually have an answer. Okay, that's, yes.
Why was that in the Supreme Court instead of the Court of Appeals?
Yeah.
Because I'm hoping to reach this issue. What happened was we briefed it, actually, the dad briefed his case, and then he filed a motion to bypass the Court of Appeals and go to the Supreme Court. And then we finished all of our briefs, and then after we were done, they took it. You know, so I don't know. Is it to reach this issue? I don't know. I kind of liked it because then I knew I didn't have to, if I won at the Court of Appeals, didn't have to wait again to get up to the Supreme Court. And they were nice to me this time. That's really why I liked it. Okay, let's just do a little tiny bit of nuts and bolts, just so you have it. You've got a few other things. The prior termination obviously must have been a sibling. Duh, it doesn't make sense if it weren't. And it has to be an involuntary termination. Now, let me talk to you about what I know happens in at least Omaha, and you guys can tell me if this happens in other places. I'd be curious. If I file a termination of parental, or in Omaha, they file a termination of parental rights motion, and the parent comes in and admits, I admit. How many times have people actually pled to it, you know? So admit, yeah, I've had it happen once. They admitted to the termination motion, and the court in Omaha makes a specific finding that that's a voluntary termination. And so, you know, is that going to be an involuntary termination for purposes of this? I think you'd have a darn, and then so of course I had that because I'm looking at the Omaha. It was a previously born baby in Omaha. I get the next kid in Lancaster County, and I look and I go, prior termination, but it was so treated like a relinquishment. I actually did some of this earlier with the county court judges maybe a year ago, and asked whether or not they thought a relinquishment was an involuntary termination, and I had a lot of them go, yeah. And I'm going, you gotta be kidding me. I mean, if you relinquish your right, that's clearly not involuntary. At least I don't think so, but we don't have any case law. Okay. Felony conduct toward the child of the parent, you know, murder. Aided or abetted first or second degree murder. These are the big ones. You know, haven't had one of those yet in Lancaster County. And this always has to be toward another child, obviously, because the kid wouldn't be alive if it had been murdered, except for the part where it was attempted or conspired to commit murder. And there is no age restriction on this part. Felony conduct has to be toward the juvenile itself, not toward a sibling. Okay, it has to be toward the juvenile. So the only part of the statute we got changed was aggravated circumstances now can be toward another child. And quite honestly, if you can prove any of these other things, you've got aggravated circumstances. So I think we've kind of made this almost moot, quite frankly. So I'm just going to go through some of this. What's felony assault? This would be at least helpful. Janet J. tells us the evidence just has to show it was a felony and it would have resulted in serious bodily injury and it was an assault. What happens if the assault occurred in a different state? You know, you had a felony assault in Iowa. Under their law, it's a felony assault. Would it work? It just says felony assault. So I would assume as long as it was a felony assault that would have been a felony assault under the law in another state, you'd be okay with that. Hopefully you'd have aggravated circumstances, so now we wouldn't have to worry about it. Okay. Serious bodily injury tells you what that is. Janet J. really addresses all these serious bodily injury things, so I'm just going to let you guys be done. Does anybody have any questions about this? You can do it at disposition. You can do it at adjudication. Wait for Hope L. Excellent.
I have a question.
Yes.
I'm going to back you up clear to the front part of the process.
Yes.
It's an issue I have with the reasonable efforts requirement. When you present, the prosecutor presents the initial affidavit and application for ex parte order.
You mean when the police remove?
Yeah.
And there have been no reasonable efforts?
Right.
That time? Yeah.
What do you, and there are no aggravating circumstances under that. What are you asking your judges to say, if anything, which I think you have to address it, with respect to reasonable efforts?
Well, and perhaps our judges can weigh in. We have one here anyway. And weigh in if the police, right? If the police remove a child, Has there been an opportunity for reasonable efforts, at least that I'm aware of? A lot of times no, because it's the first time we've ever had anything happen, right? And so what they're simply doing is saying it's an emergency because this is, you know, life-threatening situation. And when we get to the temporary custody hearing, at that time, they are addressing reasonable efforts. By then, the department should have gotten involved. Yes?
When we get to that temporary custody hearing, like 3 days later, there's been no reasonable efforts. I mean, nobody's even met this family yet. Okay, so what do you do then?
Michelle would like to talk.
I'm curious what some department folks say, because I might disagree, because unless the child was just left someplace, the department should have been involved. And so the efforts could be, just hear me out a second. If the police placed the child with the department, presumably the department went out and did some investigation, because the department had a choice. They could decide, they didn't think it was necessary to keep the child in foster care. They have been given that choice. So they decided, based on what the police told them, interviews.
That's a decision, that's not reasonable efforts.
I think it's all part of the efforts the department makes. They have to decide the best interest for that child. So they go out and they find a foster family, where to place the child, siblings, they might call
Reasonable
their
efforts to
parents.
preserve and reunify the family.
That's what we have to find.
That's what we gotta find. Reasonable
Not
efforts
whether
to
you've done
preserve.
what you should, but
Right.
whether there's reasonable efforts to prevent removal.
The facts,
Right.
and the facts like we would get, like I said, we got 3 days. The cops
Did the
pick up a
removal.
kid. They arrest the parents, so the children have to be seized, all right? The department may go out that day or the next day, and not only do they find that the parents have been arrested for possession of methamphetamine with intent to distribute, but they go into the house, and the house is a mess, and there are syringes around, and there are weapons around, and so the children clearly were endangered. There wasn't proper infrastructure for them, beds, and all of that sort of stuff. Okay, the initial ex parte order comes to us, and basically the finding, I think, that we're entering basically says reasonable efforts would not have been effective to prevent the need for removal. But then we go to the hearing 3 days later, 5 days later, and essentially we're entering that same order. And my question is that problematic? Because there's no aggravating circumstances, but there hasn't been really time to do anything to prevent the need for removal. And the parents may well still be in jail.
Well, I mean, what we see happening with department folks, first of all, is one of the reasonable efforts is providing foster care so that we can stabilize the children, okay? But the department should be doing things like trying to find appropriate relatives, at least to place with, offering services, doing their assessment. I mean, if they've never done the assessment, going out there and actually going through the assessment process, now obviously if they're in jail, it's going to be tough, okay? But let's say they're out. They do the assessment process. They could provide services to try to clean up the home. They could offer
We have more resources than we did, but
okay, and that we may be talking a real resource issue, but in Lancaster County, all of that usually happens. I can't tell you it happens in every case, but it usually happens, and it happens promptly.
I think the hang-up we have is that language, reasonable efforts to prevent the need for removal when you've got these kids that are already removed and the parents are not going to be in a position, and the department's really not going to be in a position to do much other than provide for the safety of the kids. You know, if they can find grandma, that's fine. And, you know, then kids with grandma 5 days later.
I think it depends on where the comma goes in this sentence. I'll be honest with you. I've looked at this several times. Reasonable efforts shall be made to preserve and reunify families. 1. Prior to the placement of the juvenile in foster care. 2.
which has already occurred.
To prevent or eliminate the need for removing the child from the juvenile's home. 3. And, I don't know, is that and? Is it an or? What is it? You know, I think you're right, but we're the only state in the nation, I think, I can't remember if this is right, but we're one of the only states where the police can do the removal. You know, so the department may not have even had an assessment open on a lot of these cases, right? They go in, they seize drugs, and out they go.
A lot of times, the most thing, you know, in our situation is if the police get this, they'll call up the department and say, hey, I need a caseworker to go out with me, while I arrest and.
Which is nice, we don't have that here, they call after the fact here, yes.
I think reasonable efforts can be anything, no matter how small, and if the parents are in jail, it can be that the department goes to the house and the parents aren't there. They made a reasonable effort to reunify.
I mean, because it's reasonable, it's not, it's not to prevent the removal, that's clear, but we have a weird, obviously, we have a Nebraska statute that went on top of a federal statute.
Realistically, if you're coming to a hearing, in those few days, I would say maybe the department's plan, maybe they tell you what they intend to do. We're going to make this, we're going to do this and this and this. That maybe at that point, at 48 hours or 72 hours or whatever, is something you could base a reasonable efforts finding on. Because realistically, like what you're saying, they couldn't have done more at that point. So maybe their intention or plan is okay.
And that's what we do. There's a lot of times when we haven't had time to do the assessment. We got the kid on Monday, we're having the hearing on Wednesday, but at least they've, looked up some relatives, they've talked to the parents, they're offering now a pre-treatment assessment, they're offering drug, urinalysis testing, whatever.
And the reason I'm asking the question is I would like to be able to use language other than.
What you're saying.
Other than would not have been effective to prevent the need.
Do you know if you're, we're getting 4E funding on ours, aren't we, Judge?
Yeah.
Yeah, and you're saying the same thing he is.
Well, I think what Karen says is that there may not have been an opportunity to do something at that point in time, but what are you going to offer in the future? And then if you come back and those things haven't been done, then you make no reasonable efforts.
Right.
But it's futuristic also.
And I think you don't want to lose 4E funding because but I think if you're writing in there was no opportunity because the children were removed by the police department and it was an emergency situation, and then you make the next finding that here's what they're offering, 4E funding's good. At least it has for us. So. Anything else? Thank you.